Hi there. Thanks for joining us in another installment of the SWED Education Series. Dedicated, Educated, and Celebrated. Today's presentation is related to federal decisions and the medical marijuana arena in Canada. Who is ALLARD and why do we care? We care because this is a very important case heard at the Supreme Court levels across Canada. This is a case that builds on all previous other cases. Those cases can be reviewed in more detail in the long format attached document. Right now, we are going through the 3-page summary document that you have in your hands. This is much more simplified, and it will be used for this presentation in order to ensure you have a basic fundamental understanding of what our rights are. ALLARD is one of 4 plaintiffs who challenged the MMPR using the Canadian Charter of Rights and Freedoms. Summary. The ALLARD case is about medical marijuana only. It is not a case about recreational or general legalization. The case is based on our Canadian Charter of Rights and Freedoms. This is part of the very foundation of our life and our liberties. The Supreme Courts will make sure that fundamental principles of justice are upheld, as well as our rights. For example, in Section 1, the Canadian Charter of Rights and Freedoms deals with our specific rights and freedoms and the fact that they will not be infringed upon unreasonably. Section 7 deals with the very fact that our life, liberty, and security is based on a set of fundamental principles of justice that must be adhered to. Summary continued. This case is effectively about 4 individuals taking issue with the new MMPR regulations, which had been brought into force in April of 2014. The MMPR replaced the MMAR, which had been enacted in 2001. Marijuana medical access regulations ensured that medical marijuana patients had access, had a right to cultivate and or designate a grower, and they also had a right, if they chose to, receive their supply directly from Health Canada. Once marijuana for medical purposes regulations were passed by the Conservative government, the MMAR was tossed into the quote-unquote garbage can. The Conservative government felt that it was more appropriate to have the patients access their medicine from an inflated, bloated, stock market holding set of licensed producers. That is, until a number of cases came forward. They went all the way up to the Supreme Court. In the case of ALLARD, he builds on the following information from the Smith case. In Smith, the Supreme Court was asked to determine whether or not Smith had a right to consume his medicine in whatever form he chose. In his case, it was concentrates, which were technically illegal under the Controlled Drugs and Substances Act. Canada was scolded specifically for their MMAR information. There was no monitoring, there was no inspection, there was no data that actually supported any of the claims that the MMPR was required because the MMAR was out of hand. At issue was the fact that strains, affordability, and access proved that the MMPR was failing. In fact, the judge went so far as to say that it is clearly failing and something needs to give. Background general. The MMAR had allowed medical marijuana patients to access their medicine through an authorization to possess form. This is known as the ATP. There was no daily limit on the ATP, However, there was a limit on the amount that the patient could carry, which was 30 times the daily limit. Under the MMAR, there were 3 ways to access and or cultivate your own medication. The first was the PUPL, the Personal Use Production License. If you were unable to produce on your own or wish to designate somebody, you were able to apply for a DPPL. This is a Designated Person Production License. And finally, if you were looking for supply and did not want to be cultivating, your only legal access point under the MMAR was Health Canada. To give you an idea of the explosion in growth and why this became an issue that had to be dealt with, we can take a look at a number of factors. First, take a look at the ATPs. 455 authorizations to possess were issued in 2002. By 2013, that number had ballooned to over 37,000. Wow! A factor of about 82 times, or in percentage terms, an 8,200% increase. As far as pupils go, there were 326 in 2002. By 2013, there was over 28,000, another factor of 87 or 8,700%. Incredible. The average daily dose for an MMAR patient had been approximately 18.22 grams per day, effective at the end of the year in 2013. What's interesting here is that Canada claims the MMPR was an answer to the call for safety. The MMAR was completely out of hand. It needed to be addressed according to Canada. However, the judge made it clear in his background statements that Health Canada provided no information and had effectively made some pretty bad choices. The patient's control was harshly impacted. They had no access. They were effectively stripped of their right to grow affordable, quality medicine, and they were left in limbo, having to purchase from licensed producers who were on the stock markets and demanding outrageous prices. Background: judicial. A number of cases listed in the long format piece attached to this presentation help you understand the history of the MMAR program as well as the impact it has had even today. Groundbreaking cases such as Parker, Hitzig, and Svetkopoulos all challenged the very limitations of the MMAR program. Because of those challenges and the decisions of the courts, options were enhanced for medical marijuana patients. And, interestingly enough, in almost all of these cases, Canada failed to justify the limitations or the infringements on our rights and freedoms. Effectively, patients were forced under the MMAR program to either acquire their medication illicitly or illegally, or choose their health. The system was not sustainable. There were arbitrary regulations in the MMAR, and they, quote unquote, did not meet the stated objectives. To talk about some of the significant cases that moved through the challenges, one of them is Smith. Smith challenged the concept of having to use only dried cannabis according to the MMAR regulations. It was illegal for you to take the dried cannabis and turn it into some derivative or concentrate. The judge ruled that the MMAR had an explicit right embedded into it that found all medical marijuana patients had the right to consume and access derivatives and concentrates. Smith was critical in improving the concept of medical access. It was related to the restriction on dried marijuana only. However, it provided the groundwork for the current attack on the MMPR by the ALLARD case, and it effectively attacked the entire whole integrated scheme. Background factual. Here we will take a look at a number of important facts that were outlined in the ALLARD decision. First of all, a number of witnesses provide evidence and testimony speaking about a number of very important topics. The first topic addressed was dosage. Most experts agreed that 3 to 5 grams a day was the norm. Furthermore, a number of them proposed the U-shaped consumption theory. This theory suggests that as you increase consumption, you will eventually hit a peak point and then begin to experience less effects. Eventually, these effects rebound down, forming an inverted U. This is also known as tolerance. Consumption methods were outlined. Unfortunately, no scientific evidence related to the method of consumption or that one method of consumption was better than the other was provided. There was not a single scientific study that compared dried cannabis to concentrates. Canada failed to justify these arbitrary restrictions and regulations. There was circumstantial evidence that was provided on strains and their effects. Circumstantial means, quote unquote, not scientific. Canada attempted to state that strains had no effect on the medical marijuana patients, and as such, there were no excessive limitations. The fact is, however, that the evidence clearly showed that physical and psychological effects were apparent and that patients would be negatively affected if they did not have the ability to access different strains. Cultivation can be safe, and experts made that very clear. Without the technology and the equipment, it would not be safe. However, a number of the witnesses testified very clearly that given proper planning, control, and staffing, it is possible to cultivate safely. Background factual continued. Mold safety and evidence was addressed by the court and a number of expert witnesses. The mold evidence established that local mold issues may exist, however, it would be a matter addressed by local regulation and a matter that could be addressed. It hardly called for the kind of regulation change that was, quote unquote, justified in the MMPR. Fire was also addressed. No evidence pointed to risk. In fact, the defendant's fire risk evidence was so weak and inconsistent that the Justice Phelan stated he clearly provided the plaintiff's evidence. Regarding home invasions, violence, and diversion, the witnesses for Canada were shredded to pieces. In particular, Holmquist is the most shocking example of an expert witness who is so philosophically against marijuana in any form that his report lacked balance. It was not objective. His assumptions and analysis were shredded. They were flawed. His peers in his own field did not accept the methodologies. Community evidence, legal, and bylaw compliance, as well as insurance, were all addressed. It clearly showed that there is no comparison between an illegal operation and a legal compliant one. It works. The plaintiffs, Allard et al. Et al. Is Latin for and others. Allard is a 60-year-old retired gentleman. Davy, 38, with brain injuries. Alexander was a patient who had various consumption methods the most effective being edibles, and Beamish, a 27-year-old chronically ill spouse of Hébert, her 32-year-old partner. Evidence clearly established the needs and benefits that are consistent with medical marijuana. Affordability, choice, and vulnerability were addressed. The patient's ability to pay for the amount they needed to address their medical need was clearly illustrated. The extent people must go to between choosing medicine or other life necessities was also very clearly illustrated. Choices and lifestyle constraints were clearly spoken to, and those with the worst health were most vulnerable and had the greatest level of barriers to affordability. Self-production was critical to ensure financial sustainability and savings, as well as access, quality, and therapy. Accessing the LPs was purportedly supposed to be an easier process under the MMPR. That has clearly not been the case. The restriction on the number of their strains, their prices, the ability to take on new client accounts, and in fact compassionate pricing were all reasons why the MMPR is failing. Dispensaries were considered illegal. The concept continues to be a large argument looming in the horizon. However, what is interesting is that compassionate entities, charitable or philanthropic entities, are not illegal if they are structured in the right way and operating in an appropriate manner. It was clear that the access to the LPs was impossible to sustain. Even at a $5 a gram assumption, some patients would see $7,500 per month of cash flow going out to pay for their medicine. Think about that for a second. In some cases, that means that after tax, you're talking about $100,000 a year just for your medical marijuana. That is not right. Analysis. The Charter of Rights and Freedoms protects all Canadians. In order for a charter case to be brought forward, it must be serious. The plaintiffs presented in the ALLARD case that the MMPR took away their production abilities and forced them to buy from an LP, regardless of strains, effects, or even consistent and adequate supply. Despite their ability to afford it or not, patients were forced to choose between liberty and their health. The threat of prosecution or imprisonment and the right to make a decision of fundamental importance is guaranteed under the Charter of Rights and Freedoms. Autonomy, dignity, and the right to make choices free from state interference were guaranteed in the Charter. Personal production involved many benefits, and Canada took the opposing position. The Charter of Rights and Freedoms is central not only to the case, but central to the position of SWED Society and their compassionate fellowship. It was argued that if you could not access the LP, or could not cultivate, or for any other reason, affordability, dosage, and strain, you strayed outside of the MMPR, it would be a contravention of the law. For example, if you were carrying more than 150 grams, you would risk conviction in prison under the MMPR. In the MMAR, that number would be a function of your days multiplied by 30. Personal liberty was shown to be jeopardized, and it was clear that if you have a prescription, you have a right to access. Security and dignity of person is a supreme right. Physical and psychological integrity must not be compromised, and it would not be. Canada argued not buying from an LP was a choice. The judge, however, agreed with the plaintiffs again. Analysis. Judge Phelan makes it clear that this is not about rights to cheap medicine, nor are the plaintiffs asking for the government to be obligated to subsidize costs. This case is entirely about access restrictions and the MMPR. Costs are consequences results, not independent grounds. Canada claims that strain preference is not supported by science. The LP regime facilitates access, so liberty and security are not engaged, they argue. However, the judge slams Canada again and calls conclusions they made faulty, skewed, and negligent. The plaintiffs do a fantastic job of illustrating how the MMPR causes and does not prevent harm. Patients will go without medicine or be impoverished or be forced to break the law to produce it. Patients will be fearful of criminal charges, that they will have to go underground rather than remain legal and licensed. Patients have to consume in less effective, more harmful ways. Reasonable quantities may not even be available over a legal limit. Patients would be with or without hope, and there would be no opportunity to cover up the gapped supply. The MMPR restrictions were absolutely contrary to the MMPR objectives. It did not improve access, not even close. Furthermore, the judge goes to crush the defense, Canada, again. First, he gives them grief about the insufficient evidence. Then he hammers them hard about the expert witnesses who were completely biased. Theft and criminal abuses, lethal doses, unsupported statements. The MMPR is arbitrary. Analysis continued. It is clear that the defense experts made ridiculous and unsupported statements. The MMPR goes too far. It is disconnected from the objectives of the actual regulation. The blanket statement is a restriction, and it is a complex, costly system that does not distinguish good growers from bad. There is no evidence whatsoever to support or qualify an improvement in access as the MMPR stated. In fact, they stated that budget concerns were an issue. That is not a defense. The outdoor-indoor restrictions actually even ran contrary to the MMPR. Canada slammed again. The plaintiffs argued that the negative impact on liberty and security is very high. Canada argued that jail time for cultivation is justified. Cultivation can be done safe and should not be so restrictive that it actually infringes on Section 7, says the judge. However, shortly thereafter, the judge agrees with one point that Canada has made, that the 150-gram limit is not overbroad. He finds that it bears a connection to the objective, that is, to reduce the implied risk of theft, violence, and diversion, but the judge reminds the parties that, again, there was no substantial or persuasive evidence. It was all unsupported, supposed circumstantial. Conclusion. Here we go. The good news. Effectively, Judge Phelan and the Supreme Court found that the plaintiffs had established that both their Section 7 charter rights and their Section 1 charter rights had been violated and infringed upon. The infringements were not in accordance with the principles of fundamental justice, and they were not otherwise justified. In other words, here we go. Guidance and remedy. In previous decisions related to the MMAR, the courts struck out certain words or whole provisions. In this case, the structure of the entire new regulation, the MMPR, was questioned and crucified. It would not be appropriate, feasible, or effective to strike out words or provisions. It also would not be effective to reinstate the MMAR. The judge said that striking down the current MMPR would mean a gap in legality and in legislation. This would effectively mean that anybody possessing marijuana for any purposes would be subject to a criminal offense. The judge declares a declaration of invalidity, effectively stating that the MMPR is completely invalid. However, he suspends it for 6 months in order to ensure Canada has the time to enact appropriate changes. Interestingly enough, the plaintiffs were even awarded costs. Fantastic. Thank you so much for making SWED Society a gold standard, best of class, compassionate society. Take pride. We're in this for the long haul.